Mr. Spencer has 4 cases, 24 DCCR.
4 cases, 2 fresh felonies, 1 repeat defendant. You can already sense the judge's patience wearing thin. When you walk into court, files stacked like a legal Jenga tower, you know one wrong move could send it all crashing down.
1863, charged with possession of marijuana. 25 DCCR 1149, charged with evading arrest or detention with the use of a vehicle. 25 DCCR 1150, charged with unlawful possession of a firearm by a felon. And then 24 DCCR 0841, also charged with evading arrest or detention with the use of a vehicle. And the state has filed motions in those 2 newer cases, cause numbers 25 DCCR 1149 and 1150, to raise the bond in those, or increase the bond. It looks like the current bond in each of those cases is $15,000. The bonds on those 2 previous cases, one was $7,500 and one was $25,000. And Ms. Malfino, you may proceed.
Judge, based on the fact that Mr. Spencer was out on bond, bless you, and then committed at least two additional felony offenses, we would ask.
Translation: the state just told the judge, this man treats bail like a free trial run. When prosecutors ask to raise the bond, it means they've stopped betting on good behavior.
Based on the totality of the circumstances, the nature of the offenses themselves, the court raised all of those bonds, placed him back in custody. And I will provide discovery to Mr. Kimler on the 2 new cases. He indicates today that he's going to be hired on those, but
I have you on all of them, right?
Yeah, I'm on all of them.
Okay, I'll make sure.
If everyone will give me just a minute, I am going to take judicial notice of the court's files and all of the cases, which include the probable cause affidavit in those 2, well, all of them. Give me just a second to.
Just to be clear, the offense dates on the 2 new offenses are after the other 2 offenses, is that right?
Yeah, so the offense dates on the 2, we've got the possession of marijuana offense date of February 15th of 2024, and the evading arrest or detention from March 2nd of 2024. And then we've got 2 new cases, one from June 14th of 2025, the evading arrest or detention with the use of a vehicle, and then June 15th, the unlawful possession of a firearm by a felon of this year. So give me just a second to review all of this, and then I'll let you. Sorry, I should have had these done already. Got one more I'm coming, I think. That's what I'm missing. 08. All right, so let's see. On the 2 older cases, it looks like bond was made May 24th of 2024. So he was definitely out on bond on those. When the 2 new, I should have one more.
Additional, Judge, He has been before this court before in 2017, as well as next door and the drug court.
We've got, here's,
And there it is. He was already out when he picked up the next set of charges. Let's be honest, folks. If you're out on bond, that's your last warning shot. Getting arrested again? That's like double-dipping in legal trouble.
We're gonna just go with the Class A amount. Yeah, he's gonna drag it. It's gonna be less than 750. Yeah, that should get us to the Class A. Yes, that's fine. Let's do A. That's good.
all right, so the unlawful possession of a firearm by felon and that evading, same offense, or date, pretty much same. And then, okay, I should have another one. I should have one. Is there not anything else I printed?
Two of them are the same.
I know. I should have three. These two are the same, but I should have this one and another one. I thought
That's the three printed.
okay, hold on.
Yeah.
All right.
I think I filed them in both cases.
You did. I'm just trying to find the
The same
PCs
PC.
from the, I'm trying to look at the underlying PCs as well. So give me just a second to pull up the, which one is, what am I trying to
Well, it'd be the
find?
same, probably the same PC for each case.
Evading 0841. I didn't just print this one.
Two of them look just the same, but there's two different in it.
Okay, maybe that's it. Why did it do two? What's happening? Okay. So you said he's previously been in other courts. What other, do you have convictions?
I do, Judge, I do have a conviction in this court from May of 2017, 9 months in state jail for engaging in organized criminal activity. Also, it appears that in 2017, he was also in drug court for third-degree possession. It looks like he received probation on that case. There was a knock on that, so I don't want to misrepresent that. He did get 3 years TDC on that, Judge, on revocation, and then in CDC back in 2023, he was given a lesser included Class A deadly conduct, where he served 1 year in jail.
Mr. Kimler?
Well, yeah, I'm not prepared to litigate the merits of the two new cases without compromising defense. I suppose the court will have to stand on the PCs. I know that he's employed, is that correct?
He's what's on the report. He's a
Longshoreman, and is endeavoring to maintain a law-abiding lifestyle. I believe he could pass a drug test. in lieu of an increased bond.
The defense is in full damage control mode, trying to convince the court that a GPS ankle monitor is better than jail time. It's the legal equivalent of saying, let's just give him a timeout instead of grounding him. But when there's a firearm in the mix, judges rarely buy that pitch.
The court is inclined to take some sort of remedial measures regarding Mr. Spencer's conduct while on bond for the previous 2 cases. I would suggest a GPS device in lieu of increased bond.
I don't see how a GPS is going to help when you're out on bond. You've got 2 felony convictions, a state jail and a TDC conviction. You're out on bond for a felony possession of marijuana and an evading arrest, and there's an additional arrest for an evading and an unlawful possession of a firearm by a felon. I'm going to, based on the criminal history, based on the nature of the underlying offenses, and all of the factors in 17.15, I am going to grant the state's motion to increase bond in cause numbers 251149 and 251150. I'm going to raise the bond in each of those cases to $100,000. Condition of those bonds, if made, are that Mr. Spencer not be allowed to drive a vehicle, period, on bond, and that he wear a, I'm not worried about that necessarily. Obviously can't have a firearm, but no driving whatsoever.
Boom, bond skyrockets to $100,000 per case. That's more than a legal ruling. It's the judge's way of saying, you've used up your last chance. Notice the tone. Calm, firm, final. That's a courtroom mic drop.
All right, you can go back with the bailiff, and I'll reset the case for an announcement, or the cases. And this is Mr. Coleman on Roland Guillory. Good morning, you're Roland Guillory.
And just when you think the tension's over, bam, a new case, new chaos. This time, the danger shifts from the streets to the home. The stakes move from public safety to parenting, and the judge? They're not here to play babysitter.
All right, this is 24 DCCR 1568, and
So we have an agreement except for one aspect that
Okay.
we wanted to ask the court about.
okay,
So the agreement is to plead him to a lesser included attempted endangering a child, misdemeanor, Class A misdemeanor, 2-year deferred probation, $500 fine, forfeit the weapon. He wants to have psych evaluation because he does have he has a diagnosis of bipolar. But then there was also no contact with the mother of his child and supervised visits with the child. So the case stems from his mother, meaning the child's grandmother, calling, stating that he made a statement saying he was going to harm himself and the child. So his mother calls the police. It is documented his mother was intoxicated at the time that she called the police, but so the police stop his vehicle. He lets them know he is licensed to carry. He had his gun in his holster. It was no belligerent scene, and so they removed the golden holster and took him into custody. It was, and so
just based on that, I think what I would like to do, a couple things. One, even though it's being pled down to a misdemeanor, get a PSI, which will
Okay.
give me more information, that it can also have time to get the psychological evaluation done.
Okay.
And during that time, have supervised visits. And then all that may change, but I think to be on the safe side, just pending sentencing,
Okay.
have a no unsupervised time